Please support Larry Scanlon for the appellant. We would like to divide our time, 10 and 5, reserved for rebuttal. I've reached that stage of my career where I can say things like this, and this is probably the clearest premises liability case I have ever handled in my career. The AMHA was a statutorily created political subdivision of the city of Akron. It was a landlord that provided housing in the city of Barberton through the Allen Dixon building for the disabled, whether they were young or old. And our client, the appellant here, clearly fit that description at age 64 with multiple conditions. This incident occurred the day she moved in. She had moved in that day, had never been there, and the area where she fell was an area that the maintenance guy by the name of Mr. Solinsky had painted sometime in the distant past to show a change in elevation to prevent people from backing into the curb, and it was painted white on the horizontal surface and on the vertical surface. It's not a sidewalk. It's not a sidewalk. It is a pad on which there is an air conditioning unit, and there is a transformer.
What difference does that make?
I believe that.
You call it a sidewalk or a pad?
That's right. I think the distinction is this. You know, we all know when we're on a sidewalk that we're on an elevated platform, let's say above a street or another kind of surface. But this, as you come out the back doors, it goes from 1 inch to 6 inches. So it's really hard to see a change in elevation because of the color of the concrete. You know, you're not aware, having not been there as she was that day, but my sense is, and I think the inference is, that folks are not aware they're really on a sidewalk. They're on this area where they're told to drop their boxes. She's out there, and that is what she's trying to do. That's her perception as she comes out the door.
Well, whether it's a sidewalk or a pad, it is a physical condition that presents as it presents. And the question is whether she was aware of. You're suggesting she was not aware simply because the painting was painted?
Well, I think she wasn't aware because of the subtlety of the change in elevation, but the answer is yes, we believe the liability arises here because these warning measures that had been instituted were allowed to wear off, and therefore it wasn't doing its job. And in fact, to quote the construction manager later, when they went out to paint it caution yellow, they did it so that people could actually see it. And I think that is actually the case here. So if I could continue to address that, I think the court below did sort of come back to where I think you're going, Judge, is sort of it's an open and obvious kind of hazard. And I don't believe it is. I believe the fact that they painted it shows that they did not think it was open and obvious. After all, they are in possession and control. This is a common area. The courts have routinely said, and I think we put them in our brief about, there's a heightened standard to the infirm and the aged, not just the youthful and the robust when you're maintaining your premises. In this instance of all the possible instances, this is a public housing apartment building for the aged, disabled, and the disabled. So they know they're dealing with people that have limitations. It could be sight, it could be mobility, it could be the ability to get up and down an area where there's a change in elevation. So we think this court has said in Iraq that you look at the totality of the circumstances, and the first district in the Kerr-Morris case that we put in our brief talks about those measures that were allowed to deteriorate. This isn't an instance where we're saying they should have taken action to warn. They had already done that. They had done that. You know, the best thing would have been to design that elevation out, right, with a slope. That's probably what our architect would say at trial. Short of that, you put up a fence. Short of that, you put up a
Well,
warning.
it was a slope going one direction.
Well,
You're
only
saying
at-
you wanted it to sort of like a mountainside slope down
Exactly,
all directions.
exactly. And, you know, in an abundance of caution, in a case where I really didn't think I needed it, I retained an expert and gave us an affidavit to talk about the standards that are in place here when you're dealing with the disabled, when you're dealing with these kinds of issues. And this is a combination of condition out there. It's crumbling of the concrete, it's the failure to maintain the paint, which would give you a warning of the change in elevation. And as I said, she was instructed to go out there and put her boxes there. She had just moved in, never been there, went out there, put the boxes down. She's now confined to a wheelchair. She's had 3 surgeries, very significant injury, very significant problem. And we believe that this is actually an instance where I think that we could ask the court to look at 407 on the very issue of the painting of the remedial measures. But and getting over that particular bar, generally we know that you can't use that. And we're not trying to say they were negligent in not having it yellow. We're not saying that. We're just saying they were aware that that change of elevation was not visible. That is why it was painted white on the horizontal surface and the vertical. It's a means of ingress and egress for everybody. In fact, the dumpsters are moved in and out over that pad a couple times a week, once out and once back in. And that's why the boxes were out back, right? So the dumpsters, there's a chute inside the building and the materials go down there. But this is not some isolated area where she fell. This is it's not the front of the building, it's the back of the building, it's where people park, it's where the mechanicals are, it's where the trash is. So people are in and out of that area.
How about in this case, we've got the statutory negligence per se construct, and then the common law.
That's right.
What about the fact that AMHA has pointed out that the expert did not identify a particular statute?
Well, that's because we hadn't tested him at direct or cross-examination time, but I would say that from my take on that is that this particular instance may or may not have a definite subsection of a overall guidance in the AMHA and the federal standard. May not be a specific subsection that says thou shalt have warning measures out there on a elevated change. It may be a general principle of what they are supposed to do.
Well, was something
Unlike
like that raised in the motion for summary judgment?
You mean
Was
by,
there a reference to a statute in the motion for summary judgment?
No. The defendant, from my take on what they filed, there was basically there's no duty because it's an open and obvious hazard. What we said really by looking at the landlord-tenant, we weren't seeking necessarily a per se, obviously that's something to do maybe at trial time, but we were looking at the duty imposed either under the statute where they're a landlord or under the common law where they're out there with a common area, which is the means of ingress and egress. And we're saying in either instance, either they have statutory obligation to maintain it. We know that the ADA provides a general framework for protecting the elderly and the disabled from hazards. And we know that in this instance, this owner-occupier had taken certain preventative measures to warn people of the change in elevation. That was allowed to deteriorate. We believe that the question of fact is whether or not that, had it been maintained, it would have prevented her fall. This court went all the way to the question of fact and said reasonable minds cannot come to a conclusion other than that she wouldn't have seen it. You didn't present that evidence, and I think that invades the province of the jury. We'd ask that the court reverse and remand. Thank you.
Oh, I'm sorry.
May it please the court, my name is Emily Yoder, and I represent the defendant, Applee, Akron Metropolitan Housing Authority, or AMHA. There are a couple of points that Mr. Scanlon raised that I'd like to address to start with. I believe it was represented to the court that AMHA was aware that this change in elevation was not visible, which is why the curb had been painted white. There is no evidence in the record or that was before the trial court as to why AMHA had painted that curb white.
Isn't that almost an inference that you can make? Why else would you do that?
Well, I think that there are, various inferences that can be made. As Mr. Scanlon pointed out, perhaps it was that people didn't back into it. But the fact is that evidence is not in the record. And regardless of why it is painted, I think you can look at the pictures that were taken shortly after she fell, and it is visible. You can see that there's a change in elevation, whether it's painted, whether the paint has worn off, or whether it's bright yellow. The pictures that have been presented in our briefs show that that is visible.
Well, when you look at ours on the iPad, so it's kind of hard to see all that, but obviously we'll take a look at the actual pictures in the record.
When you say it's visible, though, do you mean from the standpoint of being on the pad or being, because some of these are taken from the perspective of the parking lot, which is not apparently where Ms. Wilmoth was coming from.
Sure. And you're right. There is no evidence of what Ms. Wilmoth could or could not have seen that day, because the testimony, her testimony was that she exited the door, she exited the building with two boxes that were apparently obstructing her view. She turned to the left, she walked to the dumpster, she turned, put her boxes in the dumpster, did a U-E, and fell. So she didn't look. So I guess the point of the paint really is irrelevant, because there's no indication. Ms. Wilmoth did not testify. Had it been painted, I would have seen it. I was looking for paint. I didn't see paint. I looked, and it looked flat to me. There's none of that testimony. Her testimony is simply, I walked out, I turned left, I walked to the dumpster, threw my boxes, made a U-E, and I fell.
Well, that goes then to the issue of attendant circumstances and whether or not the fact that the entity, AMHA, I guess, should have anticipated that if this is a place where you're telling people to take boxes, that if they're carrying boxes, that their vision would be obscured while they're walking.
And perhaps that's accurate, but Ms. Wilmoth did not have the boxes in her hand at the time that she fell. The fact of the matter is she did not take reasonable precautions for her own safety to, she's in a position where she's carrying boxes and she can't see. She's in a position where she's unfamiliar with the situation, but what does she do? Throws the boxes and turns, steps without looking. This is a type of situation where she's unfamiliar, she's never been there, she can't see because of the boxes. She has a duty to protect herself against this type of situation. And AMHA as a landlord and as a property owner is not an insurer of her safety. There's several cases that are referenced in our brief that a curb is an area, it's a common occurrence. A curb is something that can be expected. It's an open and obvious hazard. It's something that we come across in our everyday lives frequently. The problem that plaintiff has with the area where this happened is the gradual incline. Again, if you look at the pictures, which I realize you don't have in front of you, but plaintiff marks on the pictures an X where she had fallen, and you can see in the photographs, it's not on the incline where she falls, it's on the curb where she falls. And this is, there's commonly a break between, a dumpster area or an air conditioning unit and a parking lot or a sidewalk in a parking lot. That's something that we commonly come across, and it's not something that a landlord or a property owner has a duty to warn against. With respect to the plaintiff's claims for violation of the Landlord-Tenant Act, there are 3 provisions that were referenced at the trial court. We've already touched on the violation of a code that a building or housing code that materially affects health and safety. I think as it was pointed out, there's no code that was violated that's been identified. There's sort of a general remark that the ADA may provide that this was improper, but there's nothing specific that's been identified that's not sufficient to establish negligence per se. And even if it was, they still have to prove, plaintiff still has to show evidence of notice and causation. There's no notice to AMHA that they were violating some unknown provision of the ADA, and there's no testimony or evidence that this alleged violation caused plaintiff's injury. With respect to the second statutory provision, that a landlord is required to make all repairs and do what is reasonably necessary to keep the premises in a fit and habitable condition. When we talk about fitness and habitability, we're talking not minor defects. We're talking about things that render a property unfit or uninhabitable. And I think as Mr. Scanlon pointed out, this was an area where residents are coming and going, they're dumping their trash. There's no evidence in the record that this has ever been an issue, that anyone else has ever fallen here. This did not affect the habitable portion of the plaintiff's apartment there. So it's our position that the second statutory provision that's been addressed is not satisfied. There's no evidence there, and summary judgment is appropriate as to that. And then with respect to the third provision of the landlord-tenant statute, we have a landlord has a duty to keep all common areas of the premises in a safe and sanitary condition. Again, this is a wheelchair, it's a gradual ramp that would allow wheelchair or handicap access to an area where people are discarding garbage. As Mr. Scanlon pointed out, this is an area where elderly, or a home where elderly or disabled people are residing. I think it would be expected that the area where you're leaving your trash would be accessible by someone in a wheelchair or someone that has difficulty getting around. Hence the gradual incline to where this area was. There's nothing in the record that this was unsafe. Simply, plaintiff didn't look where she was going and she fell off the curb.
There was something, it seems to me, in the expert's report that talked about that kind of incline being, I don't recall the precise words, but being somewhat inconsistent with regular construction.
Yeah, I didn't know what you're referring to. The expert made a comment about, I think that the change in elevation is not something that's commonly encountered.
Yeah.
There's no evidence, though, there's no testimony from the plaintiff that she hadn't ever encountered something like this, and that's what caused her to fall. And even if just because something's uncommon doesn't mean that it's unsafe. And that's the standard. A landlord has to comply with this to keep the premises safe. So just because something's uncommon is not equivalent with unsafe. With respect to the common law negligence, it's our position that there's no question of fact with respect to any of the 3 elements, duty, breach, or causation. Again, we don't know why the plaintiff fell. All we know is that she didn't look, she stepped, and she fell. There's no evidence that had AMHA done, had it been painted, or had AMHA done something that it was required to do, this wouldn't have happened. And that is necessary for a plaintiff to get this case in front of a jury. And none of that has been provided in the trial court or to this court. With respect to duty, a landlord has a common law duty to maintain the property in a reasonably safe condition, has a duty to warn of unreasonably dangerous latent conditions. This is not a latent condition. I mean, this is a curb. This is something that is commonly encountered in our everyday lives, and this is something that had the plaintiff looked, she could have seen it. She simply didn't look.
Does the fact that it was painted suggest that indeed without the paint it was laid in?
Your Honor, I don't believe so, because again, I think that the pictures speak for themselves. I also think that there's no testimony that plaintiff would have, that I looked and I didn't see it. Perhaps if that was the situation, but that's not what we have here. Also, with respect to the Kerr-Morris case relied upon by plaintiffs, I would suggest that that is a case that is limited to the specific facts there. The defendant in that case had taken it upon itself to put safety or non-slip strips in a bathtub. The dissent in that case, though, references Ohio law that provides when someone voluntarily takes on a duty and someone else relies on it, then there is a duty to discharge that with reasonable care. Here, to the extent that AMHA voluntarily took on a duty to paint the curb, the duty to maintain that only exists to the extent that plaintiff was relying on AMHA. And there's no evidence here. Plaintiff isn't saying all the other curbs in this building were painted. I expected this one to be. That's not the situation that we have here. So even if there's a question that AMHA may have voluntarily assumed this duty, there's no issue. Plaintiff hasn't presented any evidence that she relied upon that.
Can you speak briefly to the issue of attendant circumstances?
Sure. The attendant circumstances referenced by plaintiff are that she's carrying the boxes. That's a condition that she created, and frankly, carrying things is a circumstance that should make her use greater caution, not less caution. She knows that she can't see and that her vision is blocked. The boxes are not in her hand when she falls. That's very clear. She's already discarded them. So at the point that she falls, there's nothing obstructing her view. The construction in the area, when you look at plaintiff's testimony, the actual construction that she's referencing is a sawhorse in the area. There's no one doing construction work. There are not any construction workers. There is a sawhorse in the area. The other attendant circumstance referenced is boxes in the area. This is an area where they were instructed to throw their trash. The fact that trash is there is not something that's unexpected that would rise to the level of an attendant circumstance. The definition of an attendant circumstance is something that distracts a person and reduces the degree of care an ordinary person would exercise. The things that plaintiff has identified, in our opinion, do not satisfy that definition. If there aren't any further questions, that concludes my argument. Thank you. It's our position that the trial court made the correct decision to grant summary judgment. Thank you.
You have 5 minutes remaining.
Thank you. A couple of things I want to make clear. There's nothing in the record that indicates that this slope was a ramp built for the handicapped. That's just not true. This is a pad off the back of the building, and the change of elevation is created by the slope of the driveway in the parking lot. This was not created to make handicap access either easier into the building, out of the building, or to the place where this tenant was specifically instructed to discard her boxes. So it is also not true to say AMHA didn't participate in that decision. They told her to take those boxes out there. And the court, Judge, you're correct. When you look at those pictures, you're only going to be seeing them from the pictures where they were taken a couple of days later. None of those pictures, and none that I've seen, are taken from the perspective of her walking out the door and what she would have seen on the top of the pad. Those pictures are what we have. That's not what she would have been seeing. That's not what would have been visible to her. So the argument, our position is, it is a latent defect. It is a change in elevation that Mr. Stark talks about. In paragraph 6 and 7 of his affidavit is very clear. This is an unusual construction. And he believes that that this is not something you confront in your daily life. It's something that where you come out appears to be very flush, and as you move to the left and you're dropping your boxes off, she walked towards her car, and that's where it was at the highest elevation. That's why I think it was painted, to alert people. And they allowed that to deteriorate to the point the guy who painted it said, I can't even remember the last time I did it.
So the place closest to the dumpster where she dropped her boxes off is at the highest elevation?
No, it's as I understand it, the very, very highest is off the very edge, but I think where she
Beyond.
fell. Yeah,
Okay.
beyond where she fell. But she didn't walk straight off. I thought it was at an angle. I thought the picture was at an angle because she was, I've been out there, so I'm giving you evidence. That's a very narrow area where they pick up the dumpster right off the pad. The parking lot is would be off to her left as she, with her back to the building. In terms of what Mr. Stark talks about, where she's a disabled elderly person, specific changes in walkway, curb elevation without appropriate warnings, he believes violates those 2010 standards. He puts them in his affidavit, the Title II regulations of 28 CFR 35.151 and 2004 ADAAG at 36 CFR Part 191 appendices B and D. The thing I'm struck with is somehow the plaintiff should have prepared an affidavit that said, had it been painted, I would have seen it. I can imagine the outcry if I had crafted an affidavit for her to say that that was within her personal knowledge. She was asked what she was asked on cross-examination. They wouldn't have asked her, if it had been painted, do you think you would have seen it? Had I put that in an affidavit, we probably would have been accused of having her say something that she's incapable of saying under oath. If you take that argument that we've heard today, that there'd never be any duty to warn anybody about anything, because the person who would be the recipient of the warning would have to be able to say, had I been warned, I would have seen it. This is not the use of a product or how to drive a car or fasten your seatbelt. This is perceptions out there. And this is a sophisticated landlord. This isn't, just somebody who owns a couple of units in Barbados. This is a respected metropolitan housing authority that gets federal and state funds to house the elderly and disabled, and they just didn't do their job. They knew they had to have painting on that elevation change. They let it deteriorate, and she got hurt. And it's a bad injury. We've asked that you reverse the court decision and let us try the case. Thank you.
Thank you both for your presentations to the court. The court will take the matter under advisement, and a written opinion will be sent to both of you, as well as on the Supreme Court website and our own website. Thank you very much again.